This is David Olshan of Nevada Legal Services. This is another in our series of substantive law videos. This video covers the automatic stay and discharge in a bankruptcy and what to do if a creditor is violating it. What you need to understand is when you file a Chapter 7 or Chapter 13, as soon as you file, an order relief is entered and it stops most creditor actions to collect money. This includes repossessions, evictions, foreclosures, overdraft recovery from a bank, garnishments. This is a very powerful injunction that stops most creditors, but what you need to do is notify the creditors. So if a garnishment is going on, you need to notify that creditor. The court will send out a Form 309, which notifies the creditor of the bankruptcy filing and the automatic stay. Usually this is within 1 day, but if you absolutely need to get it out that day, you need to take a copy of a file-stamped petition and hand it to the creditor, because the bankruptcy court, the mailing, will take a couple of days to get there. How do you establish a violation of a stay? So let's say you file your bankruptcy and a creditor continues to garnish your wages. The creditor must have notice of the automatic stay. This is, as indicated earlier, contained in Form 309. 309A is for no asset bankruptcies. If the creditor is listed on Schedule D or EF, the creditor does get notice from the bankruptcy court, and the bankruptcy court will send out certification of service, so you can get a copy of that. And this provides the best proof of notice of the automatic stay. So this notice must go to the creditor, and you must have some proof that the creditor got it. What to do if the stay is violated? I should say that a motion should be filed. You should be represented by an attorney, and we do provide assistance here at Nevada Legal Services, so you can give us a call, but you can do this on your own. You must notify the creditor of the automatic stay and that the creditor's actions violate it. You have to file a motion for sanctions for violation of the automatic stay. The legal standard is the creditor received notice of the automatic stay. I've said that about 5 times now. The creditor's actions were intentional or willful, and the debtor, you suffered damage. So usually it is the garnishment of wages, the loss of a car and repossession, things like that. It's easy to prove damage. However, the creditor does have a defense if there's fair ground to doubt that the automatic stay barred the creditor's actions. That's the Taggart case. The Supreme Court handed that down a few years ago, and it does provide this defense to a creditor. But really, what you want is not necessarily damages, but the return of your money, the return of your car, stopping the creditor from violating the automatic stay. So let's talk about discharge injunction violations. If your debts have been discharged, meaning you've gone through a Chapter 7 or Chapter 13, all of your debts on your credit report should show 0 balances. This includes unlisted pre-petition debts. In the Ninth Circuit, if you have a no-asset bankruptcy and you forget to list a creditor, that debt is still discharged. So if the creditor tries to collect a pre-petition debt, this violates the discharge injunction, and you have to notify the creditor, supply a copy of your discharge order, because you must show that the creditor knew of the discharge and intended the actions that violated the discharge without a reasonable good faith excuse. So if you have an unlisted creditor, you have to notify them of the discharge, let them know in the Ninth Circuit this debt is discharged, and if they continue with their action to try to collect a discharged debt, you need to reopen your case and file a motion for sanctions for violating the discharge injunction. Again, that may require an attorney. It does require a filing fee to reopen your case. So contact us here at Nevada Legal Services and we can help you with that. We are Nevada Legal Services. If you need help in Southern Nevada, call 866-432-0404. In Northern Nevada, call 800-323-8666. We provide free legal assistance, and we will have more substantive law videos in the near future.